Good morning and welcome to this session of oral argument of 5th District Court of Appeals. We have one case on the docket this morning. Before we get to that, let me introduce the panel. Again, I'm Judge Sawaya, and seated to my right is Judge Torpy, and to my left is Judge Wallace. If anyone is here, and it doesn't look like there is, but I'll just announce the case of Beard v. State of Florida. Oral argument has been dispensed with, as is the case with Roberts v. Roberts. So we'll proceed with Mayer v. V.R. Moser. Each side will have 20 minutes. We have a clock on the podium that will assist you in keeping time. Any electronic devices, please turn them off. So with that, we'll go ahead and proceed.
Your Honor, may I split my time up to 14 and 6, please?
I'm sorry, I didn't hear you.
14 minutes and 6 minutes. Can I have a
6 minutes.
Okay, that's
rebuttal?
fine.
Thank you, Your Honor. May I begin?
Yes, you may. Go ahead.
Good morning. May it please the Court. My name is Preston Fields. I represent the mayors, the appellants, and the cross appellees. Before you are two primary appeals. There's a primary appeal and a cross appeal. In the primary appeal, the primary issue is whether the appellees presented competent and substantial evidence to rebut the presumption of negligence. And in the cross appeal, the primary issue is whether the trial court ruled inappropriately in denying the motion to enforce the settlement agreement, enforce the proposal for settlement. Regarding the primary case, in the answer brief, the appellees have admitted that the semi-truck rear-ended the Tahoe. They've also admitted that that creates a presumption of negligence. They've also admitted that they have the burden to show by competent substantial evidence that the presumption has been rebutted.
Evidence that there may have been a sudden lane change. Would that, doesn't that constitute an exception?
It could.
Does that kind of dissolve the presumption of negligence?
It could, Your Honor, if and only if that evidence was presented by the appellees without another contradictory statement by the same witness. That witness gave two different stories.
Wouldn't that be an issue for the jury to determine?
No, sir.
The evidence was credible?
No, sir. If one witness gives two different statements, two different positions, and they don't rebut either one, that they conflict or they cancel each other out, they're repugnant. And the sole witness that gave that statement said that he doesn't remember which one of the statements were true. His memory was not that good. So if that witness, that was Mr. Soto, again, the sole...
Was it the contradictory statements both at trial, or was one in the deposition and one at trial?
Both at trial. The first contradictory statement was a telephone call that he made to his boss right after the accident. That witness, the boss, was called at trial. He testified as to the statement. The driver was asked about that statement he made to his boss. He did not deny making the statement. That statement remained as substantive evidence, put him in the right-hand lane. He said that he didn't know where this truck came from, never saw lights. It's there all of a sudden.
If a witness testifies as to one version and then later testifies as to another version, that evidence should automatically be excluded by the jury?
What I'm saying is...
There's a case law that says that. I thought that the jury should make the determination. You can argue it to the jury and let them decide whether the first version was the truth, whether the second version was the truth, whether you have these conflicting statements, and one may be true and one may be not, or neither one true.
Right, Your Honor. There's a case in my, I think it's in the fifth point on appeal, the Molika case. That's where a party gives a statement and then rebuts that statement with another statement. Judges and juries cannot be called upon to judge which of the two statements are the truth.
The issue as to what is necessary to rebut the presumption of negligence in a rear-end collision. What do you need to do that?
You need to show competent and substantial evidence that the front driver somehow could have been at fault.
Okay, so if there's competent, substantial evidence as to one version, and then the second version, it would not be, and there's this conflict, wouldn't the jury decide which version to believe?
If it was a conflict between the front driver and the back driver, the answer would be yes. If it's the main driver, the answer is no, because the main driver cannot come in and say, allow a statement that he made to go as substantive evidence, and then give a completely opposite statement at trial and in deposition, and not explain the two. If the
You say completely different statement at trial. I believe there was confusion as far as the way, was it you or counsel for the plaintiff chose to question Mr. Moser? And the trial judge was in the courtroom and was able to decide and weigh how those questions came out and the answers came out, and ultimately made the decision that it all goes to the jury. So why aren't we giving discretion and the ability of the trial judge to do that without second guessing him up here?
I think the court, what Your Honor is referring to is actually just some confusion with the rear driver, not with Mr. Moser. Mr. Moser was very clear.
Well, it's questioning of the rear driver, and you were attacking the credibility of the rear driver,
That's correct.
And the explanation, I believe, probably the trial judge looked at it and determined the statement by Mr. Mayer?
Mr. Moser was the boss.
Right, it was Mr. Soto, who was the bullet driver, right?
Yes, sir.
So, Mr. Soto said on the phone the night of the accident, don't know where the vehicle came from, didn't see any lights.
It was there all of a sudden.
And you had your client that said there was a sudden failure of the engine, but he is certain that the lights were not affected. The jury has the opportunity to weigh the credibility of both your client and Mr. Soto and make a determination based upon all of the evidence, correct?
I totally agree, but we're not at that point. The reason we're not at that point, Your Honor, is because Mr. Soto said he didn't see lights, and then later he testified that he did see lights. He testified that, or Mr. Moser testified that the vehicle was there all of a sudden. Mr. Soto testified at trial that he saw it a quarter mile up the road. Mr. Soto said...
The statement that he didn't see lights, did he contradict that statement in the telephone conversation with Mr. Moser?
Yes, sir.
He contradicted the statement
Absolutely.
that he saw lights when he talked to Mr. Moser.
I'm sorry. He said that in the telephone conference, or the telephone call, he did not see lights.
And then you're saying the contradictory statement was at trial?
Yes, sir.
After how many years had passed between that? 2 or 3 years?
I think 2 or 3 years, Your Honor.
Okay.
And also, he said it came out of nowhere on the telephone call, and at trial, he said he saw it a quarter of a mile up the road, and it took him a while to catch up. There was questions about where the trailer was and that the Tahoe was in the transfer. There's questions of whether or not he actually transferred all the way over, whether or not it was sudden, because in the trial transcript, originally, Mr. Soto denied rear-ending the Tahoe. Then when I showed him the trial pictures of all the crush damage, he finally had to admit, not only did he hit it, but he drove it down into the ditch, and he was embedded in it at the end of when they stopped. So what we have here is, yes, sir. Okay. What we have here is 2 different statements from one witness. When you have that cannot serve as competent and substantial evidence. In addition to that, if I can also comment that Mr. Soto,
The case that you cited, is that a case that is in the same procedural posture as the instant case?
on the Molika case about the 2 positions, I think that was against the state of, that was a different issue, Judge. It was with the state of Florida. It was a criminal case, more of a sworn statement.
Do you have a case like this case where the appellate court said that you were entitled to a verdict notwithstanding, or a judgment notwithstanding the verdict?
I only had...
Because a witness gave conflicting testimony.
I have it again, it's a criminal case. I have it for a new trial. I think that's in point number 5 I raised in my brief.
Which case is that?
That is the Molika case.
Oh, I thought you told me that the Molika case was a different...
Well, it's on more of a... it's a criminal case. It's after the fact, and there was 2 statements that were made by the same witness, and they both were sworn. The appellee is going to come up and say that this wasn't a sworn statement to Mr. Moser, but I asked him about it under oath during the trial, and he did not deny it. So therefore, the failure to deny and to distance himself from the statement is substantive evidence. If I can also comment, when I asked Mr. Soto about the conversation, about the 2 different positions, his position was, I don't remember. My memory is not that good. So if the sole witness is not able to testify which of the two stories is correct, that's not competent substantial evidence. And finally, on this point, I asked him about Mr. Mayer's driving, the driver, the front vehicle. He said that Mr. Mayer did not drive carelessly. And if you look at the appellee's brief, the answer brief on page 40, this is what they said. Mr. Soto's testimony that he did not think Mr. Mayer drove carelessly is put forth as a defining evidence that there can be no comparative negligence on behalf of Mr. Mayer. Mr. Soto's opinion is just that, his opinion. The jury had a different opinion when it held Mr. Mayer 75% at fault. If the only witness, the only witness was Mr. Soto, if he said that Mr. Mayer did not drive carelessly, and the appellees are seeking to distance themselves from that opinion.
You're saying that the trial judge should have directed a verdict in this
Yes.
case?
Yeah, absolutely, yes, sir.
What's the standard for directing a verdict?
De novo, Your Honor.
Pardon?
De novo.
And if the trial judge sees that there's, tell me the standard that the trial judge is supposed to utilize in determining whether to grant the judgment for directing a verdict.
Judge, the trial judge has got to look to see if there's any competent substantial evidence to support the position of the appellant.
Does he take the evidence in the light most favorable to the?
Absolutely, Your Honor.
You're not supposed to do that? And then if there's any doubts, you would resolve those in favor of letting the jury decide it?
Yes, sir, and I think that's what happened, and that's why we moved for a directed verdict.
Would that be an appropriate ruling in this case, even though you've got as you said, according to your argument, conflicting testimony from one witness? You say, well, let the jury decide it. You know, there's one version that would be sufficient. There's another that may not, and let the jury decide.
Right, the fundamental position is, Your Honor, if one witness, if the only evidence comes from one witness, and that witness testifies as to a position and allows another position that he said to his boss remain as substantive evidence without contradicting it, it remains as substantive evidence and they conflict, a court cannot allow internally conflicting.
It's not like the jury totally, rejected, his argument for liability. They accepted it. They just, awarded a higher percentage of comparative negligence than you would have liked.
That's correct, Your Honor.
That's the problem.
Right, but my position is that the jury, even though the court submitted it to the jury, by giving a jury instruction and allowing a jury to decide the issue, when you have two conflicting positions, that's not what the trial judge technically is supposed to do. The trial judge's position is...
So if we accept your argument, then any time that a witness gives conflicting testimony, then the trial judge automatically grants directed verdict.
The trial judge...
There's no other substantial competent evidence from the trial judge. Is that a matter of law that the trial judge is supposed to do that now? How does that work?
It's my position that the answer would be yes, because if the two people, if the one person, the two stories, the two conflicting stories, he cannot, the fact that it's two conflicting stories cannot rise to the competent substantial evidence position. And regarding the statement of the driver...
But have you ever seen a case that says that as a matter of law, that, if there's conflicting testimony from one witness, and that's the crux of the case, that as a matter of law, that the directed verdict should be granted?
I've got the case of Malika for the new trial.
Besides that one?
Sir?
Besides that one?
Besides that one, no, sir.
So besides that one, then this would be the only other opinion. If we were to write an opinion like that, that would be it. I mean, that would create some new precedent, right?
I think it would clarify the position of Malika, because with Malika is saying that the two positions, you cannot have that. You cannot have two conflicting positions, especially if they cancel themselves out.
I follow your argument.
Yes, sir. Judge, real quickly, I see my time is running down. Regarding the issue of I'm sorry, Judge. Mr. Soto commented himself that he did not think that Mr. Mayer drove carelessly, and the appellees are seeking to distance themselves from that opinion. It's on page 40 of the answer brief. Judge, real quickly on the proposals for settlement, when you look at them, that's de novo also. They want to make a big issue about there being two general releases, but when you look at the proposal, they only did one, It's a joint proposal. Everything in it requires both of the plaintiffs to accept. And notice that my time is quickly run, Judge. I'll reserve...
If you wanted to go past you wanted to reserve 6 minutes, it's up to you, however you want to use it.
I'd like to reserve it in case my co-counsel... Thank you, Your Honor.
We'll do that. May proceed.
Good morning. May it please the court. My name is Greg Lockaby, and I represent the appellees and the cross appellants in this case. I believe the court has hit right on the head the issue in this case, and I believe, as I've set out in the brief, that it is a believability and a credibility case. And I believe you...
The facts in the light most favorable to
the
your client are what? What are the facts in the light?
That there are two versions to this accident, one given by Mr. Mayer, which he never wavered from, that he's in the right lane the entire time, and the other by Mr. Soto, which he never wavered from, he's in the left lane.
His position was that there was a sudden lane change. The
Yes.
plaintiff made a sudden lane.
Mr. Soto's position, our position is that there was a sudden lane change directly in front of Mr. Soto's semi, and that in and of itself is sufficient evidence to go to the jury to rebut the presumption on the rear-end collision. Okay. As to the points that were made on the variances in the testimony by Mr. Soto, I don't believe the Malika case that was referred to is applicable here, because the Malika case dealt with sworn testimony given at trial and then sworn testimony given in a deposition post-trial, the second sworn testimony not being heard by the jury. And the Malika case says in that case the judge can't choose which story to believe. That's different than the situation we have in this case, because all versions of this accident and conflicts that may be in those versions were heard by the jury in front of the trial court, and it is at that point a conflict in the testimony and the evidence that goes to the believability and the credibility of the witnesses. I find it interesting that at the time the plaintiff rested in this case, and the court asked me if I had any motions. I said I can't in good faith make a motion on liability because I think it's a jury issue, and opposing counsel agreed with that. Now the point is, nothing changed in the evidence in my case in chief, because both Mr. Mayer, Mr. Moser, and Mr. Soto all testified in the plaintiff's case in chief.
Address the offer of judgment issue?
Sure. On the proposal for settlement offers of judgment, I believe they comply with both the statute 76879 and 1.442.
Did the proposal for settlement state clearly that either party could accept the offer irrespective of the decision made by the other plaintiff?
In those specific words, no. But when you have two separate releases, one addressing Mr. Mayer and one addressing Ms. Mayer, and there's nothing in those releases that ties one to the other or requires them both to accept or reject, I believe that's sufficient to comply.
I think it's paragraph C. I don't know if there's a number before it. It clearly does not differentiate between the two plaintiffs. It's paragraph C. This proposal for settlement is conditioned upon acceptance by plaintiffs within 30 days after service of this proposal, and the plaintiff's execution of a general release. It doesn't in any way differentiate that one or the other could accept, correct?
In that interpretation, correct. I believe...
The interpretation, it's the plain language of paragraph C.
I
You could have written paragraph C any other way. You could have provided or served two proposals for settlement individually to the two plaintiffs, correct?
Could have.
And chose not to do that.
Correct.
Okay.
But it's still my position that they comply with the overall intent of the rule and the statute.
Well, isn't there an ambiguity that would at least give the plaintiffs the perception or the requirement that if you're going to accept it, everybody has to accept it as phrased or as the amounts are given here in the proposal for settlement?
I don't perceive it that way because of the separate releases. I mean, there's nothing in the statute of the rule that says everything in the general release has to be included in the proposal and everything in the proposal has to be included in the general release. And I think the fact that there's two distinct releases makes it clear that one or the other or both can accept or reject. I understand what you're saying. It could have been...
In the case, the attorney's title versus Gorka case, which I think both parties referred to, clearly states the offer of judgment, which is your proposal for settlement, must state that either offeree can independently evaluate and settle his or her respective claims by accepting the proposal, irrespective of the other party's decision, correct?
Right.
Okay, and so your OJ did not say that.
It didn't say that, but when you look at it in a common sense fashion, which the case law also says you are supposed to do, the fact that there are separate releases is certainly indicative of that. One can accept or not, and the other can accept or not. But they both can accept, they both can reject. I mean that's our position. I just think when you look at it in total, which case law says you're supposed to look at it in total, I think it's a reasonable conclusion that one or the other could accept the proposal and leave the other to his or her own decision. I would also reference you to what I have noted as a State Farm case, which says on the particularity issue, it may be impossible to remove all ambiguity, and it should only be considered an ambiguity if it affects one party's decision to accept. And I go back to the two separate releases addressing the two separate individuals does indicate that they have separate decisions to make, and one or the other, again, can accept or reject. And I would also, point out the comments made by the second DCA in the Newby case, which is the point I'm trying to make. When reviewing offers of judgment, court should use reason and common sense to interpret the offer as a whole to avoid unreasonable results, and that the parties should not nitpick what they perceive to be alleged ambiguities if it doesn't affect the ability or the decision to accept it or reject it. And I just think it's clear to me, maybe not to everybody, but it's clear to me that with two separate releases, it's clear that they have their choice to make individually. With that, unless there are any other questions, I'll sit down.
Okay, thank you.
Thank you.
Regarding the two separate releases, that is one view, and I acknowledge his view as a potential view. It's a great argument for him to make. The problem he has with that argument is they drafted the proposal. The proposal is very specific regarding both plaintiffs settling, dismissing all claims. So as far as the proposal for settlement, we would ask the court to affirm the trial court. Looking at trying to conclude the main appeal, Your Honor, when you have two conflicting positions by the same witness, that one witness admits in the trial that his memory is not that good, and he admits that the main driver was not careless. Those three factors, when combined together, preclude that sole witness's evidence from rising to the level of competent substantial evidence. With that being said, the trial court should have granted a directed verdict either at the time or later. At this point, we ask this court to reverse the trial court's denial of the three motions, and preferably the motion denying the motion for a directed verdict, with instructions to the trial court to enter a directed verdict, and either reset this case for a new trial on damages or address the issue of the additor, because although we haven't really touched on the issue of the damages, he had a mild traumatic brain injury, cognitive problems, broken scapular, and fractured spine and fractured ribs.
The jury awarded damages for each component that you argued to the jury for,
Yes, sir.
correct?
Yes, sir.
So you're just unhappy with the amount, correct?
I believe that the amount is so low that it appears to me that they did not follow the competent and substantial evidence that was presented before them on the issue of the economic damages and the pain and suffering. Because if you look at the pain and suffering, Your Honor, $40,000 for a brain injury with a surgical recommendation and permanent injury, all the orthopedics acknowledge, even theirs, that he had a permanent injury, that he needs surgery.
I guess the jury also had in front of it the testimony that your client had consistently elected to forego surgery.
Yes, sir.
And he, very shortly after the accident, I guess returned to light work within 2 weeks and then to full duty work and was given ultimately a 6% impairment rating. Is that correct?
I don't think he ever returned to full work. I think he's still doing light work. It just takes him longer to do the jobs because of the pain in the collarbone area.
Okay. Well, the jury had that evidence to consider.
Yes, Your Honor, it did. So, but when the court looks at the liability issue and looks at the damages issue, it just appears that from our position that they didn't properly view the evidence, and we would ask the court to reset the case or grant the motion for a new trial on the issue of damages. Your Honor, unless there's any questions, I think I've made my points. Thank you very much.